Just before I start, I just looking at the transcript towards the end of the last session, and it might have appeared that I submitted that I didn't expect law to follow the logic before this court, and that's not what I was saying.
Well, we didn't hold that against. We didn't understand you to have said that.
Very good. So a number of questions were asked of me. What I propose to do is just answer those questions and then go on to my submissions dealing with the second round of appeal. And the first issue is I was asked what do we mean by a property policy? This is, and I think Mr. Justice Butcher accepted this was a property policy, and all I mean by that is rather than financial losses such as loss of profits, loss of revenue, etc., or expenses being insured, or rather than legal liability being insured, what's insured is property. And what engages cover is either a physical loss of property, which means a deprivation of possession or whatever, or it means a physical damage. And so once you've got either physical loss or physical damage, so long as the assured has an insurable interest in the property, there is then a claim. And there may be an issue about the measure of indemnity, but that's what I mean by property policy. Now, why that's important in this case, I say, is because whilst Quadra did pay in advance 80% of the purchase price for a number of consignments, they represent nothing more than a financial loss, an expenditure without any acquisition of an insurable interest in property. Now, of course, I think the starting point in one sense, and I think this is something which is common ground, I think was obviously accepted by Mr. Justice Butcher, if the goods were never there to begin with, so Quadra paid for goods which did not exist, there would be no claim under this policy because there is no loss of property. And of course, there's no insurable interest in that property. Now, of course, the money.
When you say if the goods were not there, sorry, I appreciate. Are you saying goods not matching the what description were not where?
So just assume you've got a Zaplasky warehouse receipt saying we hold for your account 5,000 tons of corn.
Yeah.
And there was no corn on the premises at all, right. or no goods on the premises at all. Then even though they may have paid for that warehouse receipt, there is no loss of property under the policy. And I think that should be an uncontroversial statement or proposition. So where it gets more complicated, of course, is where there are some goods, but not all the goods. And the goods aren't identified or attributed or allocated, or however you wish to put it, for the purposes of Quadra. Now, the other extreme, which is clear, of course, if there are goods which Quadra paid for, and Quadra paid for all the corn in bin number 427 in the Zaplasky warehouse, so that the goods have been identified by agreement between the parties, and therefore either Quadra has title or will get title in one way to those goods, then if those goods are lost, there is a claim under the insurance policy.
That would never happen because that's not the basis the warehouse operates on.
Well, it depends on, it depends.
Okay, it depends on the terms and conditions of the warehouse, which are in the bundle, and which say that the warehouse can mix lots of grain and it operates on an unsegregated basis.
Well, but in this particular case, there was an example, Mr. Justice Butcher refers to it, where there was segregation of cargo for the account of a particular customer. I can show you that.
That must be by separate, that presumably is by separate contract with the warehouse, because it's not the terms and conditions that Quadra.
No, but it's not saying it's beyond it's still something one could do in relation to any goods held in a particular warehouse. Yeah. So and Mr. Justice Butcher refers to that. Yeah. So they're the two extremes: no goods existing, or goods are allocated in some way or identified by agreement for the benefit of the relevant trader, such as Quadra. So we're in the realm in the middle. And I'll come to the authorities, but it is worth noting, as I pause here, that there are no authorities, but the authorities which do discuss insurable interest are all cases where either the goods are on board a vessel or in a store which are identified. And so and there is no authority which deals with the wider implications of goods which are unascertained and unidentified in terms of being identified by agreement between the warehouse and the insured. And that's where we're, if you like, brave new territory.
So, perhaps you can give me at least the reference to the specific example of somebody who arranged for segregation of their grain, but the warehouse storage agreement I was looking at is at 227 and 228 of the supplemental bundle, which simply says the grain in the warehouse is stored non-segregated. Mixing of grain lots with similar grain in the warehouse facility is allowed. And if that's the basis on which the warehouse operates, namely that it just has on-site corn, wheat, barley of particular descriptions in a total amount, in a aggregate amount that hopefully matches the warehouse receipts which it has issued. Are you saying that somebody can validly insure against those warehouse receipts or not?
Well, if it's operating in relation to these terms and conditions, which allows Quadra to select or deselect or identify or mix or match cargoes, then I accept that's unlikely. But if that's what you're asking, maybe I've misunderstood my lord.
Sorry, I'm not sure. Sorry, did you say Quadra could select them?
Sorry, I meant the warehouse.
22728, if we look at it, is clause 2.3 is the one that my lord has put to you.
Yes.
Grain warehouse stored non-segregated, mixing of grain lots for similar grain in warehouse facility.
So this is obviously an agreement specifically between the warehouse and Quadra.
Yeah. Okay, but it describes how the warehouse operates as Bailey.
Yeah.
So just to that, but it doesn't mean Zaplasky can't segregate cargo for the benefit of particular.
No, I understand that. If somebody says, look, I'm really keen that in the wine shipper's case, it would be really, my wine is so special, it has to be identified,
Correct.
stored separately, whatever. But just going back to clause 2.3,
Yes.
that's in general terms how the warehouse appears to operate, or at least it's a warehouse operating on that basis.
Very good.
Let's assume that warehouse operates
Yes.
on that basis
Yes.
with a number of customers. Are you saying that those customers can or cannot validly enter into an insurance contract in relation to quantities of grain at a warehouse which operates on that basis?
They could not enter into an insurance contract. They could enter an insurance contract in relation to cargoes which have been as a property insurance as opposed to, they could certainly insure against any financial losses.
Yeah.
So that's separate. But as a property insurance, unless the goods are identified, then no insurable interest will attach to those goods. Now, there may be an issue as to how you define identification. But until you do, what Quadra is doing by this term is actually saying we're going to hold goods on a non-segregated basis, and we can supply to you whatever grain we wish. Now, in those circumstances, the grain can never be identified, and that's the logic. And my lord, just to go back to the example, paragraph 111 of Mr. Justice Butcher's judgment refers to an instance where there was segregation.
Yeah.
For a particular customer, not here. So what I'm trying to deal with is this middle ground between the two extremes which I've identified. And if Zaplasky says we hold 5,000 tons of cargo, according to the warehouse receipt for the account of Quadra, then those goods can be supplied according to the contract by the warehouse to Quadra, whatever stock they have in the premises at the time of delivery. That's the contract. The contract of sale, and I appreciate there are issues about title, contemplates for at least the Zaplaski and the Bilgerod warehouses that title doesn't transfer until later when the goods are removed from this inland terminal and taken to the seaport. And that's what the judge found below. So that all is of one, that there's no intention on the part of the warehouse to actually identify any goods which are allocated to the benefit of Quadra. Now, my Lord Justice Popplewell asked before, and my Lord, I'll come back to the BMW example in a moment, but as far as the what happens if Quadra has the benefit of this warehouse receipt for 5,000 tons. Now, the logic of that, if that gives an insurable interest, and there is no allocated or no identified goods in the facility, then any time that the warehouse removes 5,000 tons, even entirely innocently, to someone else and delivers it to someone else, because, for example, they have the intention to give another 5,000 tons to Quadra, which they may change their mind about, that would represent a loss to Quadra. And that can't be right, because then they would have a cause of action at that very point in time when no one's doing anything wrong. The facility is operating entirely in
the hypothesis is they have got another 5,000 that is available for Quadra at that time, or they haven't at that time?
Well, at the time of delivery, or at the time
you said they've taken 5,000 and delivered to someone else, is the hypothesis that they have then still got enough in the warehouse to give to Quadra, or not?
I thought, I was actually, with respect, I thought I was just putting to you the premise you put to me. And if the premise was there were other 5,000 ton parcels, I would say there couldn't be any losses. But even if the premise was there's only one 5,000 ton parcel left when the warehouse receipt is issued, and that's given to multiple persons, unless there's an agreement that that's the 5,000 tons which will be given to Quadra, that won't be enough to give rise to an insurable interest. Now, of course, even if there's only 5,000 tons left, the warehouse acting innocently might buy in further quantities of cargo to make good on the Quadra sale later. But just because there's only 5,000 tons left and say, look, we've got plenty of barley, we've got plenty of corn, we haven't got much wheat, we'll just get rid of the corn and barley first, and then we'll buy more wheat later. And so all that's left is 5,000 tons of wheat, and they promise that to Quadra. But just because they get rid of it and deliver it to someone else, the intention may be to go and get new wheat later on. That's not a loss to Quadra.
Well, it is if the intention is unfulfilled.
If there's an agreed identification of that 5,000 tons to Quadra, I accept.
No, it's simply part of a bulk. There was enough bulk there beforehand. After the first 5,000's been moved, on the hypothesis you're positing, there isn't enough. There may be an intention in the future. But there isn't enough. There is a loss at that stage. It may be that the loss is made good by a substitute parcel at a later stage.
But if they were to go into liquidation at that point, there's a loss.
Well, this goes back to my Lord the Chancellor's question about the BMWs, because if there's only 5,000 tons left in the facility, just assume, and that's I mean we don't know what was in the facility, but assuming there's only 5,000 tons left, and that was. A warehouse receipt was issued to 6 traders, each for 5,000 tons. And assume the first one was effective in the sense that validly granted either an ownership interest or a possessory interest of some sort to that trader. The removal of that 5,000 tons would be a loss to the first trader, but not to the others. In the same way, going back to the BMW example, the Chancellor referred to it before the break, if there were 3 BMWs in the car showroom and the promise was to sell one, and actually the dealer pointed out and identified one of them to the purchaser, but they've all been sold to someone else first, the purchaser's lost nothing because they're never going to be his cars. Never. Because he's bought a car which is not his.
That's a matter
it can
of
never
property.
be delivered.
That's a matter of property, not insurable interest. That's the difficulty I'm having.
But it could never. It's something you can't have. You can't have an insurable interest in goods which you don't have no expectation of obtaining, or earning a profit.
Certainly an expectation of obtaining them, both in the BMW
well,
example
not a legitimate
and in the example you're given. They paid for them. They're expecting to get them.
Well, let me, it can't be a loss to the purchaser when there is no prospect as a matter of law that vehicle or those 5,000 tonnes would ever end up with this particular purchaser. It can't be. So if someone can't sell goods which they don't own because they've already sold them to someone else, the person who's agreed to buy them has suffered the loss of money in paying for them, but hasn't suffered the loss of property. The same is true if there's a right to possession is granted to someone else. Either one person's got a right to possession or the other person has. But you can't, once it's been lost, it was lost before even he decided to purchase it, because it's been allocated to someone else altogether. And in those circumstances, I would submit anyway, my lord, is that there can be no property loss in those circumstances. And I think my lord,
So is the proposition that there can't be a property loss if title has already passed to someone else? Is that the proposition?
If there could be no benefit, so that if I paid for goods which belong to someone else, I can't see how there could be an insurable interest in those goods, unless you have a successful competing interest, which is unlikely. And can I put it another way, my lords? Just imagine there was, and I'll go from BMW to 5,000 tonnes of wheat in a second, but if I start with the BMW, just imagine that you have a dealer that's got 3 BMWs, and he agrees to sell one of them, and he identifies it by registration number to the purchaser. And actually, then he never receives it. And then he makes a claim under his insurance policy. Now, the insurers are subrogated to the rights of the purchaser against anyone, the lost property, but he can never exercise the right to salvage in relation to that property because it's never his.
If it all depends on property, why do we distinguish between risk and property?
Because as between a buyer and a seller, the risk identifies who has to bear the loss of the property. And that's between buyer and seller.
It'd be rather surprising if the person who has to suffer the risk of the loss, who is not, on this hypothesis, the property owner, couldn't insure against that risk. That's what happens. People who bear the risk insure against it.
Yes, because that's true, because a buyer
They
may...
don't have the property.
No, but there is a distinction, if I may, my lord, between the examples I've given and a buyer and seller of goods. So, for example, title may not pass until negotiation of documents, but risk may pass at shipment. And so the buyer is expecting to receive title. As between the seller and buyer, the understanding is that the buyer will receive those goods, but is agreeing, even before title is received, to bear the risk.
Suppose the seller sold them to someone else, which brings it closer to your example, unbeknownst to the buyer.
Well,
Buyer can't insure because he's never going to get title as a matter of law, as you put it. He doesn't have an expectation as a matter of law because someone else has already got title.
Because it must be expectation as understood as between the buyer and the seller, and the seller had already sold the goods to someone else. Then there is no risk and also no title which can attach to the buyer. None, because it's not his goods, and it will never be his goods.
No title, but risk.
No, not risk either, because the first thing the buyer will do is say, well, you haven't supplied me with any goods. The contract's cancelled. Any risk which would revert back to the seller. Can't be. Just imagine the seller trying to sue the buyer because he's saying you have to bear the consequences of this loss, but because you've agreed to bear the risk of it. But the seller's actually defrauded the buyer by selling it to someone else. That can't be right.
But the buyer has paid the seller in advance, let us suppose, and has insured. And
For goods he'll never receive.
And can't claim on the insurance.
No, because firstly, because they're goods they'll never receive. Because they've been sold to someone. If that's the premise, if they've been sold to someone else.
It's at his risk, but he can't insure.
Well, I don't think that.
This is what you're saying, isn't it?
No, it's not, because risk arises commonly in a different scenario. Risk arises where the seller genuinely sells goods to the buyer, and before the goods, the documents and therefore title is transferred. Let's say the ship sinks, and the goods are lost. In those circumstances, the buyer's got what's called a contingent interest, and it can insure against that, even though they haven't got title yet. And that's clear. But the scenario you're putting forward, my lord, if I may say so, is entirely different. That's where the seller sells the goods entirely to someone else. In those circumstances, it doesn't make sense to speak of risk and title because they're not going to be goods which are passed to the buyer. They can't be. They're always being sold to someone else, unless you have an exception to the name of DAC rule, but putting that aside.
So your submission depends upon saying that, I know it all derives from an American case, but the passage that the judge quotes at paragraph 84 of his judgment from McGillivray has been in every edition since the first edition. If neither property nor risk has passed, payment or part payment of the price will give the buyer an insurable interest, because if the goods were lost or damaged and the seller was insolvent, the buyer might not be able to recover the money which he had paid for them. That's just wrong.
No, because I've accepted, my lord, and I don't want to. I hope I'm not being inflammatory in any way. I don't mean to be. But what I'm saying is, no, that's not wrong. What I'm focusing on here, I'm not disputing that an advance payment can't constitute an insurable interest.
You're inserting an additional requirement. The goods have to have been in some way either ascertained
or identified.
And where do I find that in any of the?
Because it hasn't been addressed by anyone yet. This is why I say it's brave new territory.
But I think, as I understood it, you're adding a further requirement that the goods must be such that it's possible for you to acquire property in them. So if in the example we had, goods are shipped, buyer pays in advance, whilst the goods are afloat, seller sells again and negotiates the documents to someone else, cargo sinks, you say no insurable interest, because although if he hadn't sold them elsewhere, there would be an expectation of property passing. Because there is no longer an expectation of property passing, no insurable interest. So as I understand it, you're saying that's an additional requirement.
For this purpose, for the purpose of this case, I don't need to go that far. Because I was doing it to address the examples which have been put to me in questions. All I need to...
Going back to your point about logic earlier on, we have, don't we, to look at the logical consequences of the submissions you make.
I know
that is the logical consequence of the submission.
No, but, I do want you to consider the logical consequences, and I'll come back to those. But I don't need to go far.
I mean, the point goes around in a circle in a sense, and I don't mean that in an offensive way.
No.
But it goes around in a circle because if the goods are unascertained, and they form part of an unidentified bulk, then by definition you can't have property in them. Section 20A. But unless there's an express provision of a contract.
Correct, but nor I say can you have an insurable interest in them.
Well, that's the point though, and therefore the reason why I think that's the point my lord's been putting what you're really saying is that you can't have an insurable interest in this example unless you could also have property.
No, because let me give you an example. Just imagine the warehouse in this case had said, Quadra, we're going to sell to you 5,000 tons in bin number 427 in the Zaplasky warehouse. So they're identified. Now but we know also under the contract, delivery won't take place until the seaport. So therefore title won't pass, but we know that they've paid in advance for these ascertained or identified goods. So they don't, if they're lost, they have a valid claim, even though they haven't got title. So the title's not
only if that particular bin contains the exact quantity and no more. Because I think if they've done that for two people,
no, because
there's enough for both of them in the same bin.
There'll be enough because it's an identified bulk. So long as if Quadra only being 5,000 tons and there was 10,000 tons in that bin.
But why is it not therefore? I'm afraid I asked this question before. If that's true of a single bin, why is it not a sufficiently identified bulk if they're all on the same premises?
Well, that's because until they're identified, because all the premises, it's a question of definition of what identified bulk means for this purpose of insurable interest as opposed to the Sale of Goods Act. But if you're talking about general stock, which is held by, and you're basically saying anything can come out of my general stock, the very concept of stock, general stock, is that goods can be bought and sold in and out, and they'll never be identified. So you don't know which goods will have been lost or damaged for the purposes of the property policy. And so it's not enough to say that the entire warehouse will be the goods. But I'm going to come on to identification later. I just want to establish, and I don't mean to cut you short, my lord, but I just want to establish the principle before I come on to what the... So my first point is you has to be identification, and then I'll address what identification means for these purposes. But in terms of the logical consequences, I mean, just imagine you have a scenario where, going back to the example we gave before, you have 5,000 tons of wheat, which has been promised, if you like, by way of a warehouse receipt to 6 individuals, 6 traders. And those 5,000 tons are lost. So the logic of the argument being put forward by Quadra is that each of those traders, under their own separate insurance policies, can claim 6 times the value of those goods, so taken together, so accumulated. So each would claim the full measure of indemnity in relation to those goods under their own policy. So collectively, the insurers under those 6 policies will pay for 30,000 tons of goods rather than 5. Now that creates all sorts of difficulties, because what happens, for example, if those 6 traders are actually co-insured under a composite policy? Now, because the composite policy is in essence separate contracts of insurance with each composite assured, even though it's contained in the one policy, are you saying that the one insurer will have to pay 6 times the loss for the one single loss of 5,000 tons? That just can't be right. And what happens if the insurers then have pay out a claim? How do they exercise, say one insurer pays out a claim and another insurer pays out a claim, they all get rights to subrogation. What do they do with that single 5,000 tons? They don't, not all of them, they can't exercise rights to salvage in it because they've all paid for the same cargo. Property insurance has never worked on that basis, ever. Every property insurance claim I can even think of contemplates there'll be a single loss of property and one compensation will be paid. And my lords, if there's 2 people interested in the same goods, you still only recover the value of the goods, and then they have to be shared between the individual traders. And that's true, my lords, also, and going back to the logical consequences, even if those who are interested are not parties to the insurance contract. So this is the principle in Thomas and Hepburn. So you've got Thomas and Hepburn where a carrier insures goods to the full value, and the true owner is not an insured. And there is a loss. And the House of Lords said that was a legitimate insurance, even though the carrier's interest is only worth a small proportion of the value, because the carrier can recover the full value and then account to the others for all their insurable interests. So taking that principle forward, just imagine each of these insurers insuring 6 different traders who have got, if you like, an insurable interest on Quadra's analysis in the single 5,000 ton consignment. The logic is that each one of those indemnities which are paid to each of the traders then have to be accounted to the other traders insofar as it exceeds their interest. That's a very strange state of affairs. Now, I was proposing to proceed with my submissions. I hope I was trying to answer your questions before lunch, and I hope I've done so. So where I start is the very reasons, as a matter of logic, why you have to identify goods and work out whether there is title to it, apply equally to a possessory interest and apply equally to any insurable interest. Every case which has been considered by this court and below concerning insurable interest, the goods themselves or the property themselves have been identified. I can't think of a case where there haven't been. And the way in which the general principles are identified by the judges in the past is always by reference to either the specific article or the thing insured, which contemplates that there is some identification of the subject matter of insurance. So, just on that first step, there's a decision which we refer to in my skeleton, which is Devaney in Kenya, which just makes the point that you can have, when you identify a bulk, that's relevant not only for the purposes of title, but also for the right to possession or possessory interest. Can I take you to that decision? So it's tab, Authorities Bundle tab 2. Sorry, bundle 2, sorry. Tab 15. So in this case, it was a decision of the Divisional Court constituted by Mr. Justice Leggett and Sir Richard Akins, where the issue was whether or not Mr. Devaney should be extradited to Kenya in relation to various offences with which he'd been charged. And he was a director of a company called Triton, which traded with the owner of an oil storage facility in relation to petroleum products. And the question arose whether there was a prima facie case to be met by Mr. Devaney. And the central question was whether or not there could be relevant theft offences in relation to goods which were undivided bulks. So I think you can pick it up at paragraph 21 at the bottom of page 300.
So sorry, could you just give me that reference again?
Oh, so bottom of page 300,
Thank you.
page 21, paragraph 21. So having looked at the contractual arrangements, the court said the effect of these clauses in the CFA 2004 is in summary that Triton was contractually obliged to inform KPC, that's the facility, of the names of the signatories of the financier who could authorise the release of Triton of petroleum products held by KPC. And once KPC received instructions from this signatory, then KPC was obliged to release the goods. KPC was obliged to keep the records and was obliged to issue regular statements to financiers of Triton of the petroleum products to which Triton was entitled within the KPC system. And then the court says at paragraph 22, analysed in English terms, the effect of Triton informing KPC of the authorised signatories was to put KPC on notice of the fact that a certain consignment of petroleum product was the subject of a finance agreement, and to instruct KPC to hold the product for the account of the financier until further instructions. When KPC then notified the financier that it was holding the product for the account of the financier, this constituted an attornment by KPC as bailey of the goods to the relevant financier. So this is basically saying goods held by KPC created a bailment, and the bailment was in favour of the financier by virtue of an attornment. By doing this, KPC gave to the financier constructive possession of the goods. The financier thereby acquired a security interest. And then they speculate this is a pledge. And then in paragraph 23, you can see the argument. Mr. Jones advanced some general arguments based on English law, we assume, about the ownership or consignment of petroleum products that had been sold to Triton for delivery at the KPC installation, but which was part of a larger consignment of a cargo of the same product in a ship or became part of a larger consignment of the same type and grade that was stored by KPC. In English law, the position is, we think, as follows. First, a buyer of goods such as oil, which form part of an undivided bulk, can become the owner in common with others of the entire bulk, with a right to withdraw its share of the bulk, provided that under the terms of the contract, the conditions for property passing to the buyer have been fulfilled. I think it says see section 28, subsection 3, but I think that should actually be 28, subsection 1 of the Sale of Goods Act. Secondly, if a buyer has such a proprietary interest in an undivided bulk, then it must follow this interest can be used as security for the performance of an obligation owed to another person, someone who has advanced money to finance the purchase of goods in return for obtaining a security interest. Thirdly, if a person takes physical possession of an entire bulk but has notice of the identity of the owners of the bulk and their individual shares in it, then the relationship of bailor and bailee will exist. And fourthly, if the bailee then returns to a third party, the effect will be to put the third party in constructive possession of the bailor's undivided share. And then I think we can go to in paragraph 24, you should just note, I suppose, TSA 2007 was a contract for bailment between Triton and KPC, which set out the terms on which KPC would take possession and hold then release products that were owned by Triton. We reject the argument that KPC could not have been bailee for Triton of any petroleum product in bulk, which it was entitled to withdraw a share. By the same token, we also reject his argument that the financiers to whom KPC gave undertakings to hold product for their account could not thereby have acquired any proprietary or possessory interest in the goods. And then in paragraph 51, which is at page 314, you can see the issue which is being addressed is whether there was a prima facie case test satisfied in respect of each of the charges alleged, which are allegations of theft. And at 315, at paragraphs 56 onwards, you see Mr. Jones submitted that in circumstances where oil purchased by Triton was intermingled with other product in KPC's storage system, there was no identifiable chattel of which KPC could be a bailee on which the financier could acquire a proprietary or possessory interest as security. Furthermore, letters issued by KPC to financiers undertaking to hold consignments of oil for their account were merely gratuitous promises unsupported by consideration. I think we can. And then in the next paragraph, in our view, this argument is misconceived. It's based on the faulty premise that there cannot be a proprietary or possessory interest in goods which form part of an undivided bulk. As discussed in English law, that is not correct where the requirements of section 20A, subsection 1, I think, are satisfied. In such circumstances where KPC issued a letter of undertaking to a financier involved in a CFA arrangement to hold a consignment of petroleum product purchased by Triton and received by KPC to the account of the financier, this was from the point of view of English law an interment which put the financier in constructive possession. If Triton or Mr. Devaney then dealt with Triton's relevant share in the bulk in a manner that was inconsistent with the possessory interest, that would amount to the tort of unlawful interference with goods, or in the old-fashioned term, conversion. By the same token, such conduct would amount to appropriation of property within the meaning of sections 1 and 3. And then I think I ignore the rest. So there, what's being made good is that this notion of identifying a bulk is not just relevant to questions of title, but also relevant to the questions of right to possession. Now, of course, the Sale of Goods Act doesn't actually impose any rules about the identification of bulk for the purposes of possessory interest. It's only concerned with the sale of title. But it demonstrates that the court was prepared to accept, for the purpose of identifying what an identification of a bulk is, or what the rules are in relation to an undivided bulk is, they'll apply the same test. And that makes good sense, we would say. Now, therefore, that leaves over the issue about advance payments. Because if there's no title, then we say because the goods haven't been identified, equally there can't be any right to possession because the goods can't be identified. Then you have the question, can you have an insurable interest by making an advance payment in relation to goods which are not identified, which is nothing more than an advance payment. And for this, my lord, I'm going to have to go to the authorities referred to by the judge. There's 3, I think, which I'm going to refer to.
Yeah.
Including Lucina. Sorry, is it Lucina?
Well, who knows?
Okay. Well, if I say either, that's what I mean in this case. But there are 4 points I just want to make about these authorities before I progress to them. And the 4 points are these: that in each of these cases, the subject matter insured was plainly identified and identifiable. Whether it was a named ship or goods on a named ship or a designated bulk. The second is, in these cases, the identification of the bulk or the goods was not in issue. The third point is what was in issue was the nature of the insurable interest, where there is no ownership interest. And the fourth point is there was in none of these cases was there competing interests for the same goods or the same subject matter.
So competing interest.
For the same subject matter or same goods. So looking at Lucina first, which is the first authorities bundle tab 2, sorry. So this is where I think it was during the Napoleonic Wars, there was the Commissioners of Admiralty had taken possession of Dutch ships, and they wanted to insure the vessels for the voyage from St. Helena to England. And the question was whether the commissioners had a sufficient insurable interest to support such a policy. War was soon after declared against the United Provinces, and the ships were condemned as prize to the crown. And the question, upon the loss happening, the commissioners made a claim. And the question was whether or not they had a good insurance claim. And the court, the House of Lords, held that they did. Now, this is one of those cases, my lords, where the House of Lords called for the assistance of 9 judges who would form part of the Court of Common Pleas or the Court of King's Bench or the Exchequer Court, all the common law courts. And I think 9 of them gave them the opinion, and what happens is they each express a view, and of course the House of Lords then decide the case based on the opinion of the judges. And you can see the question, the relevant question is at page 12 of the report, where you see the 5th question. I'm not going to read it out, but basically the question is whether the commissioners had an insurable interest. That's the 5th question. Page 12, I'm so sorry, page 12. You can see the word 5th for that, the first bullet point. There's a number.
Oh, yeah.
And then you can see at page 19, the majority of the judges, so this is not the decision of the House of Lords, it's the common law judges who gave their opinion. And the majority answered there was a insurable interest. But the influential judgment is that at page 21, which is page 4, I'm so sorry. This is the decision of Mr. Justice Lawrence, where he actually answered the negative. There was no insurable interest. And you can see about, I guess, 12 lines from the top, just before the first bullet point. So the first hole punch. It says, a man is interested in a thing. So a man is interested in a thing to whom advantage may arise, or prejudice happen from the circumstances which may attend it. A quantum mea interfuit. And I'll let the Latin speak to it for itself, and then I'll go on. And whom it importeth that its condition as to safety or other quality should continue. Interest does not necessarily imply a right to the whole or a part of a thing, nor necessarily and exclusively that which may be the subject of privation, but having some relation to or concern in the subject of the insurance, which relation or concern by the happening of the perils insured against may be so affected as to produce a damage, detriment, or prejudice to the person insuring. And where a man is so circumstanced with respect to matters exposed to certain risks or dangers to have a moral certainty of advantage or benefit, but for those risks or dangers he may be said to be interested in the safety of the thing. To be interested in the preservation of a thing is to be circumstanced with respect to it, as to have a benefit from its existence, prejudice from its destruction. The property of a thing and the interest advisable from it may be very different. For the first, the price is generally the measure, but by interest in a thing, every benefit and advantage arising out of depending upon such thing may be considered as being comprehended. And that's the test which is now adopted by the House of Lords later in the century, and then reflected in Section 5 of the Marine Insurance Act. And then you have Lord Eldon's judgment at page 321. Sorry, which is, sorry, a big one. Page 31, it's 321 of the original report. And you can see, just where it said 321, just about 6 lines below that, where he says, I have in vain endeavoured, however, to find a fit definition of that which is between a certainty and an expectation, nor am I able to point out what is an interest unless it be a right in the property, or a right derivable out of some contract about the property, which in either case may be lost upon some contingency, affecting the possession or enjoyment of the party. So so all this sets out the decision. Ms. Justice Butcher relied upon it, but all it really indicates is there is a flexible definition of what insurable interest is, but it's talking about, again, the relationship between the assured and the property on the one, the assured on the one hand, the property on the other. You still have to identify what the property or the thing is. In its case, it was clear because it was named ships. So then that's one decision. The other decision which Mr. Justice Butcher relied upon was Cumberland, which is the decision of the Court of Maine, which you can see at tab 5. And here, there was essentially 150 tons of what was called fish scrap. And I think you can pick it up at page 95, where the decision of Mr. Justice Barrows. And the plaintiffs claim to recover a loss of $2,000 under a policy issued by the defendants upon a stock of fish scrap contained in the Atlantic Oil Company's works in Booth Bay. And I think we could go to the next page. So the jury, this is the paragraph beginning the jury, would be authorised to find then that Luther Maddox, a manufacturer of porgy oil and fish scrap, dry and crude, in pursuance of negotiations with the plaintiffs looking to his furthering them with large quantities of dried fish scrap, had received advances from the plaintiffs before the taking out of the policy to the amount of $2,000, and the dried fish scrap on hand to an amount of value considerably exceeding the sum advanced by the plaintiffs. As the fish scrap or porgy chum was not wanted by the claimants until the following season, it remained at oil company's works, not separated from that belonging to Maddox, under Maddox's agreement to store it for the plaintiff free of expense and deliver it when wanted, and to get it insured in order to secure the plaintiff's advances. In pursuance of this agreement, Maddox told the agent of the defendant company that plaintiffs had scrap at Booth Bay, that they had made advances to him to the amount of $2,000, and he wanted a policy to protect their interest in case of loss. He procured a policy on his own interest at the same time for a like amount. The cash value of the whole stock of fish scrap at the time of the insurance and of the fire was $5,000, and it was very nearly a total loss. No part of it had ever been delivered to the plaintiffs, but Maddox stated fully to the agent of the insurance company the situation and condition of the stock and the risk the company was taking just as it was. He testified in substance that the porgy chum burned was the same upon which the plaintiffs had made the advancement to him, that there were 150 tons in the whole, of which he owned 3/5, and the Cumberland Bone Company 2/5 by virtue of the advances made him, that he held it for them to be delivered as he wanted. So just pausing there, what we're talking about is 150 tons, 60% owned by the if you like, the seller or manufacturer, and the other 40% by the purchaser, because they made an advance payment, but not owned, not because it hadn't been delivered. It was an undivided bulk. So on page 97, the court rejected the notion that there had to be a legal title, legal property for an insurable interest. And then he refers to the classic definitions. And then at page 98, you see Mr. Arnold in his treatise on insurance, premising that it is very difficult to give any definition of insurable interest, states is it as the fair result of the cases that in order to have an insurable interest, it's not necessary to have an absolute vested ownership or property in that which is insured. it is sufficient to have a right in the thing insured or a right derivable out of some contract about the thing insured of such a nature that the party insuring may have a benefit from its preservation and prejudice from its destruction. So, my lords, what I say is the thing insured has to be something which is ascertainable and identifiable. We think that the plaintiffs, under the facts here, had such an interest in the subject of insurance. Maddox was holding it in good faith in trust for them. He recognised the interest they had acquired in it by their advances, held it subject to their order, and procured the insurance in their name to protect their advances, refraining from insuring it in his own and making known to Mr. Plummer, the defendant's agent, the situation and condition of the property and the fact that advancements had been made to him thereon by the plaintiffs, and that the object of the policy was to protect those advances. It's true that so long as Maddox was solvent, the plaintiffs might not lose by the destruction of the property. The same is true of every mortgage or pledgee. We fail to see how the insurers could be injuriously affected, supposing it true that the agent understood that the part belonging to the plaintiffs had been separated, weighed off, and formally delivered. It does not appear that the risk they assume was changed or affected. So what's interesting about this decision is that the court was dealing with an identified bulk, but undivided as between the manufacturer and the seller and the purchaser.
Identified in the sense that it was all that was
The
on
150 tons.
premises.
Yes, and all we know is that 60% was owned by, or if you like, treated as the sellers, and 40% was treated as the purchasers. And that obviously adds up, forgive me for saying 100%. So, but that gives you the whole of the bulk. And what was interesting about the decision is that the court basically looked at this by reference to the need to identify a relationship, if you like, with the thing insured. And the court equated what the advance payment with the position of a pledgee or a mortgagee. Now, when it comes to rights of possession or proprietary interests, you must have goods which are identified. And it's very difficult to see why an advance payment should be treated differently. Why should it be treated differently in terms of identification of goods from questions of title, possessory interest, pledges, security interests, or mortgagees? And I say there's no good reason. There can't be some special reason to be attributed to advance payments for this purpose. So the question of identification of goods should be something which is stable and applicable for all purposes as far as insurable interests are concerned. And the other interesting thing about this decision is that the way the court asked the question is, how could the insurers be injuriously affected by this? Because they can't. Because if the goods have been delivered, or whether they've been retained by the seller, the insurers would be in exactly the same position. Now, take the present case, my lords. Just imagine we have one insurer, Insurer A, who insure each of the 6 traders, each of whom have received a warehouse receipt for for the same 5,000 tons, described 5,000 tons of goods. Just assume that's the case. And assume also that they've all paid it in advance, and they're all entitled, according to Mr. Justice Butcher's judgment, to an indemnity for that full amount. Now, why this matters is because if there's only one insurer, rather than a number of insurers, insuring each of these 6 traders, for the very one loss of 5,000 tons, the insurer is being made to pay 6 times. And that would injuriously affect the position of the insurers. And the way to test that is, of course, applying the very same test which Mr. Justice Barrows did. If the goods actually had been delivered to each, you test it by reference to what would have happened if they had been delivered to each of these purchasers, each of these persons who had paid in advance. And the truth is they couldn't.
But why is it injurious to insurers? They've taken 6 lots of premium, each of which
Well, just be careful.
is premised, one assumes, on a loss of the amount of the loss which occurs.
Well, my lord, if you're assuming, and forgive me, I don't know if this is part of your question, but if you're assuming that the premium will be retained, it won't, because under Section 84 of the Marine Insurance Act, if there is no insurable interest in the part of the insured, it's returnable.
No, you seem to persuade us that it would be unfair to the insurers to have to pay 6 times the value of the property that's lost.
Correct. For the same,
And
for the loss of the one
I'm
consignment.
suggesting to you that since they've taken 6 times the premium, and the premium is calculated, one assumes, on the risk of the loss of one parcel of that size, why is that unfair?
Because what Mr. Justice Barrow was doing, he was comparing the position where the goods hadn't been delivered to the purchaser and where they had been delivered to the purchaser. And he said there was no difference. In the case of the sale to 6 different, well, not sale, but the issue of a warehouse receipt to 6 different, you would never get a delivery to all 6. You'd only get a delivery to
No,
one.
the point I'm putting to you is,
Yeah.
if there weren't a loss at all,
Yes.
they're getting 6 lots of premium.
Not if they have insurable interest, because they have to return it. If there's insurable,
This is all on the hypothesis that there is an insurable interest. You're saying to us, if the judge is right that there was an insurable interest, and one consequence of that is that the insurer who has insured all 6 is liable to pay out 6 times over. And what we're putting to you is, well, why is that particularly injurious in circumstances where they've got the premium 6 times over?
because, my lord, there are 2 answers to that question. The first is they're paying 6 indemnities for the loss of one set of goods. And secondly, if they're all insured, and I'll explore this later on, because I've already summarised this, their rights of subrogation are affected. The obligations of the insureds to account for other persons' interests in the same set of goods will be affected. And it just doesn't make sense. And my lord, the second answer is if it's a question of, well, is it really fair given that the insurers are receiving a premium? That is not a relevant consideration for this court. For the reason is, either there's insurable interest or there is not. And if there's not, the premium's returnable. So you can't ask, well, that means that somehow or other the insurers are benefiting from premium when...
That's not the point.
No, I know that, but...
The point's being put to you is
I
a different
understand.
point. It's a point to answer the suggestion that somehow this is prejudicial to the insurer.
Well, may I ask rhetorically, and I'm not requiring an answer, is have you ever heard of a scenario where there's been one loss of goods, a single consignment of goods, where multiple indemnities have been paid to various persons who may be said to be interested? The normal position is where you have a variety of people interested in the same goods, they have to share the indemnity. It's not they don't each get a full value. That does not happen. So if you have a policy which insures an owner and a mortgagee separately, and there's a loss of the ship.
And that's a composite policy. That's a policy.
One
policy.
They each have a separate policy.
Yeah.
And they each can't recover the full value because they have to account to the other. And once they account to the other, they can't each keep the monies because there's over indemnification. But once you've got a composite policy just means there's 2 contracts of insurance in the same policy. There's still 2 contracts of insurance, and it shouldn't have any different effect. Sorry, my lords, I'm just conscious of time, and that's not to say I don't enjoy this. I enjoy the answering your questions, but I don't want to
I'd like us
stop
to exercise a little more restraint.
Sorry?
Very delicately put.
We will be
We
quiet.
will.
I'm not asking you to be quiet, because I much prefer it if I'm engaging. But,
So we looked at Cumberland Bone. Where are we going next?
Inglis and Stock.
Yep.
So this is the final decision I want to refer to. It's a tab 6. And what's interesting about this case, this is the case which, if you like, anticipated the change in the law in 1990 odd, when the Sale of Goods Act was amended to include provisions for title to undivided bulks. Because what this decision actually said was that, or held, was that the purchaser of a part of an undivided bulk, which again, in this case was identified because it was on a named ship, could have an insurable interest. And we obviously don't take issue with it. We think this is absolutely right. And you can see what happened was there was 390 tons or 3,900 bags of sugar loaded on board a ship. But there were essentially 2 consignments. And oddly, both of them ended up with the same purchaser, but they went through a different contractual sale route. And I think the first page is 266, I'd like to go to. And you can see at page 102, this is the Lord Chancellor speaking. The quantity actually put on board the City of Dublin, this is the first full paragraph on the page, at Hamburg was only 3,900 bags or 390 tonnes. I think enough to say that if the plaintiffs would have had an insurable interest in 4,000 bags under the circumstances, he had, in my opinion, such an interest through the quantity, though the quantity was short by 10 tonnes. No bulk sugar belonging to Drake & Co. was put on board the ship. The 3,900 bags was therefore specifically separated from the bulk of the vendor's own sugar. So that here we've got a undivided bulk, but it itself was separated from the vendor's own stock. And they were shipped under the Drake & Co.'s contracts with Bellow and the plaintiff with a view to, and in fulfillment of the agreement of Drake as vendors to put the purchased sugars free on board. The present controversy arises out of the manner in which this was done. Each bag was distinguished by a mark denoting its percentage of saccharine matter and 10 bills of lading from parcels, bearing marks corresponding with those on the bags were made out in personal form and sent to Drake & Co. And then it goes on, the aggregate consignment was proper and suitable to fill the contracts without exceeding as to either than the average 90% of saccharine matter. The no particular bags were then set apart or marked as applicable to the one contract more than the other. It was thought sufficient by Drake to leave this to be done when the bills of lading came forward. There'd be no practical difficulty in doing so in a proper and reasonable way, even if the plaintiff had not purchased Bellow's contract, inasmuch as neither purchaser could claim, and Drake & Co. were not to be paid for any excess beyond 90%. It was conceivably possible that it might have been done perversely and unreasonably. The division was in fact made by Drake & Co. who forwarded the invoices of the parcels attributed to each purchaser. And then I think in the next paragraph, it's contended on the part of the appellant that under these circumstances and for want of a proper division before the loss, the shipment had not the effect of divesting the prior title of Drake, the vendors, or of passing any interest in these sugars to the plaintiff. This argument appears to me to confound two very different concepts of things. The appropriation necessary as between vendor and purchaser, and the division as between purchaser and purchaser of specific goods actually appropriated to the aggregate of the two contracts. I do not think it follows that there can be no appropriation by the vendor of which the purchaser might take the benefit, merely because the parcels of goods appropriated were mixed in the act of appropriation, so as to require some subsequent division or appropriation. I think that we're taking up the next, top of the next page. Well, that should be bottom of page 103. I see no reason to doubt that the difficulty arising from the confusion of parcels, material only to the settlement of the amounts payable by the plaintiff to his vendors, would have been soluble by principles of law applied to the facts and the terms of the contract. The necessity for doing this and the fact that it had not been done at the time of the loss do not, in my opinion, sufficiently distinguish this case from Brown and Hare. The goods were, by the act of the vendors, separated from the bulk of all other goods belonging to them. They were shipped free on board in what was the purchaser's ship, under two contracts to deliver them, in both which contracts the plaintiff was then solely interested, because he was the ultimate purchaser of everything. And then Lord Blackburn says as much, page 274, and I don't need to go through that. But what's interesting, of course, is that what was obviously important as far as the Lord Chancellor was concerned is there was an insurable interest in this undivided bulk. The bulk was identified because it was the tonnage actually put on board this named ship, City of Dublin. But it had been segregated from the bulk of the vendor's own sugar, their own stock. That's what is obviously makes this a fair case, because even though the title may not have passed, it was this cargo which was always destined in one way or another, because it had been identified or allocated to Now, the question then becomes, if I'm right about this question of identifying either the goods themselves by appropriation or by other means, or by identifying the bulk. What do we mean by for this purpose, for the bulk? And what I'd like to do is double this up, because my learned friend has a respondent's notice in relation to the question of what constitutes the bulk for the purposes of Section 20A, and I can address both at the same time, as it were. And for this purpose, it's probably worth looking at the legislation, which is the beginning of this authorities bundle.
So where is the link to?
I'm sorry, Michael.
Where are we looking?
At the beginning of the authorities bundle, tab 1, same bundle. So the sale of goods.
Where are you going with this? Are you saying that for insurable interest, bulk means the same as it does for passing a property under 20A?
My submission to you is that the purpose of identifying the bulk of which the relevant goods form part should, as a matter of principle, be the same as the Sale of Goods Act, because, for the same reason which was really adopted by the Divisional Court, which is when you're dealing with right to possession and title, it should be the same. And when you're dealing with other insurable interests, it would be very odd to have a different definition, because you need to have stability and clarity in what constitutes an insurable interest. And for that purpose, you need to identify the subject matter of the insurance. But at the same time as I address you on this, I'm also addressing a respondent's notice point about whether or not there was a transfer of title under Section 20A. So I'm trying to do two things at once, if that's clear. If it's not clear, I can make it clearer. So we've got Section 16 on page 4. So subject to Section 20A below, where there's a contract for the sale of unascertained goods, no property is transferred to the buyer unless and until the goods are ascertained. And of course, that's a provision which has been long with us. So traditionally that meant if you had an undivided bulk, before Section 20A, there could be no title to any part of that bulk until it had been ascertained. For example, it had been separated from the undivided bulk. But that law was changed with the introduction of Section 20A, which you see at page 6. And here you've got, this section applies to a contract for the sale of a specified quantity of unascertained goods if the following conditions are met. A, the goods or some of them form part of a bulk which is identified either in the contract or by subsequent agreement between the parties. And B, the buyer has paid the price for some or all of the goods which are the subject of the contract and which form part of the bulk. And of course, we've got a position here where 80% of the purchase price has been paid. And so what we're really concerned with is the identification of the bulk, or whether there's been an agreement for it. Now, just to remind my lords, Mr. Justice Butcher held that there was no title to the under Section 20A passing to Quadra because there was no identified bulk. And as I say, my learned friend has a respondent's notice in relation to that point. And then the last definition we need to look at is that of bulk, which you will see at page 8 under Section 61, subsection 1. Bulk means a mass or collection of goods of the same kind, which is A, contained in a defined space or area, and B, is such that any goods in the bulk are interchangeable with any other goods therein of the same number or quantity. So what that essentially means is there has to be a mass or a collection of the same goods. It's contained in the same defined area or space. And the goods in the mass or collection have to be interchangeable with any other goods of the same number or quantity. Now, the Law Commission addressed this, and if you go to the second bundle of authorities, at tab 22 so paragraph 212. Sorry, 2.12 on page 527. the Law Commission say, although Section 16 prevents property and goods forming part of a bulk from passing before ascertainment, it does not prevent risk from passing and does not prevent the purchase for a quantity forming part of a bulk from acquiring an insurable interest in the goods before ascertainment. And Inglis and Stock is quoted or cited as in favour of that proposition. But of course, remember, Inglis and Stock is concerned with an identified bulk on a named ship. It's common enough for the risk of loss or damage to the goods to pass to the buyer before the property passes. A buyer of goods out of bulk who is prevented by Section 16 from acquiring property in the goods may still have to bear the loss if the goods are lost or damaged, and should therefore, even under the present law, consider insurance. And I'd say there's nothing unobjectionable about that at all. Nothing objectionable about that at all. And then we go to 529, where we have the recommendations of the Law Commission. And at 4.3, under the heading Identified Bulk, it is clearly necessary that the goods should form part of an identified bulk. Property cannot pass in wholly unascertained goods. We suggest that bulk should be defined as a mass or collection of goods of the same kind, contained in a defined space or area, and such that any goods in the bulk are interchangeable with any other goods therein of the same number or quantity. We consider that the bulk must be identified by the parties as containing the goods which are the subject of the contract. Examples of such bulks would be, and you've got an example, cargo of wheat in a named ship, massive barley in an identified silo, oil in an identified storage tank, and the examples go on. But of course, what you have there are all references to naming or identification of the places where the goods are kept. And it goes on to say, the definitions intend to exclude a seller's general stock. A person who buys a quantity of unascertained goods to be delivered out of the seller's general stock would not be buying an item out of an identified bulk, although the concept of an identified bulk would find its most natural application in relation to mercantile sales of commodities such as grain, feedstuffs, oils, and other materials commonly dealt with in bulk. It could on occasion apply to consumer contracts. Now, I think I can ignore that for the present purposes. Yes, in 4.5 it just says that the bulk can be identified either in the contract or by subsequent agreement. So we've got, you've got under 4.6, you've got reference to a prepaying buyer. There are arguments for and against confining the reform to the buyer who's paid for the goods before delivery. Against this limitation, it can be, because you may remember, my lords, that that's the second requirement for the provisions in Section 20A to apply. Against this limitation, it can be said that the existing law allows property and specific or ascertained goods to pass, whether or not the price has been paid, and that it would be more consistent to stick to this principle. Would give greater contractual freedom to the parties if there were no restrictions to the prepaying buyer. Many consultees favoured allowing the intention of the parties to prevail. The main argument in favour of confining reform to the prepaying buyer is that it's sufficient to meet the injustice which needs to be remedied. Buyers who have not paid are not greatly prejudiced by the existing law. They still have their money and they cannot normally be forced to part with it except in exchange for the goods. It is prepaying buyers who are seriously prejudiced by the existing law. They're liable to lose both their money and the goods. There are also pragmatic arguments in favour of confining the reform to prepaying buyers. And it goes on, I don't need to deal with it. But what's interesting here is, what the Law Commission is contemplating is that when you have an undivided bulk, but which is identified and it's prepaid for, that would constitute both a loss of money and a loss of goods. Now, in this case, as I said, as far as my learned friend's response notice is concerned, I may have to deal with this in reply, but the important point is that for the reasons given by Mr. Justice Butcher in his judgment, paragraphs 100 to 113, he basically, 112, he rejects the argument that there was a transfer of title under Section 20A because essentially, the relevant, for example, at paragraph 106, he says, this is page 137 of tab 8 of the call. To recap, the warehouse receipts identified that a specified quantity of a particular grain was stored at the elevator's warehouses located at the address of the elevator. The evidence establishes that each of the elevators had several warehouses or buildings. Furthermore, each elevator stored different types of grain and grades of grain, and it appears that grains and grades of grain were moved between silos. And then he concludes at paragraph 112 for the reasons he gives in these paragraphs, that there was no such transfer of title. But at paragraph 108, he refers to a decision of the Singapore High Court in RBG against Banque Continental, and it's worth just looking at that, which is it's the Authorities Bundle 1, tab 12. And the claims here, I think, for nickel and tin. Page 236. You can see the heading, the bulk claim, paragraph 57 onwards, and there's a reference to section 20A, which is relevant for our purposes. And 59, there was no dispute. It was the sale of a specified quantity of unascertained goods. And then you've got reference to the Law Commission report at 60 and 61. And then paragraph 62, there's reference to the fact the Commission said that the proposed definition was intended to exclude a seller's stock. At 63, the judge said, relying on the statement, the liquidators argued that since RBG was in the business of buying and selling metals, the metals in the warehouses were part of the general trading stock and hence should be excluded from the definition of bulk. I do not agree with that approach. The Commission's statement was followed by another sentence, and I set it out below. The definition is intended to exclude seller's general stock. A person who buys a quantity of unascertained goods to be delivered out of the seller's general stock would not be buying an item out of an identified bulk. I'm of the view that general stock was intended to be excluded because it would not be an identified bulk. However, if a bulk comes within the definition of section 61 and it is identified, it will come within section 20A, even if the identified bulk is also part of the general stock. The real question on the requirement is whether there was bulk within the definition of section 61 and whether it's been identified. So the point here is just the mere fact that the bulk may be identified but within the general stock, that's not problematic. So if there was an identified bin number, for example, within the entire facility, that would be okay. As will be recalled, the definition of bulk refers to a mass or collection of goods of the same kind. And in the examples given by the Commission, reference was made to gold, all of the same kind. In the case before me, the metals in the Fujitrans warehouse were not all the same kind. They were copper, nickel, and tin. Nickel, copper, and tin might each have constituted a sub-bulk of metal of the same kind as a different point. Furthermore, the warehouse receipts did not identify the location of the particular warehouse in which the metals were stored. Each warehouse receipt was on the letterhead of Fujitrans and was a reference in its contents only to in-warehouse Singapore. I've set out the full text of one such warehouse at paragraph 28, which you can see earlier in the judgment. Likewise, the monthly confirmations from Fujitrans also did not identify the location of the particular warehouse. The cover letter from CL forwarding each monthly summary for confirmation also did not identify the location of the particular warehouse. It simply referred to a summary of base metal stock stored within your warehouse facilities at a certain date. As regards the third statement, it had to be established that the bulk was identified either in each contract or by subsequent agreement, and I don't need to look at that. So what was interesting, it was by way of comparison, it was something which influenced the judge. He said it was analogous to the present case, and therefore there was no title to the...
But it wasn't there was more than one warehouse, and the warehouse wasn't identified. and the goods that were in the warehouse were not all the same. There were three different types of metal.
Yes, but in this particular case, as the judge said in his judgment, we've got one large facility made up of individual warehouse, individual bins, and that none of those bins or warehouses were identified in the warehouse receipt, and that's what influenced him to say no title. And I'm coming on to the issue whether this is sufficient for the purposes of other forms of insurable interest, but just dealing with the respondent's point, that's where the judge came out. Now, we would say, as far as the title is concerned, it's not enough just to identify the whole facility, the whole warehouse, because there are numerous interests going on, and in some respects, the goods are just held for any number of traders. And what would really be expected, particularly when goods are removed and resupplied without any goods having been allocated to a trader, that is not sufficient for the purpose of identifying a bulk. And it's very simple. Just imagine, my lords, that there was 50,000 tons of corn, and there was a warehouse receipt for 5,000 tons. That was going to be removed and replenished, and it's not an identified bulk because it's changing constantly, as the contract with Quadra makes it clear.
Hang on, sorry.
Yes, of course.
We're probably about to speak in stereo, I suspect.
Well, is it not part of an identified bulk from time to time? Just because it changes.
Because I think what's
On any given day, why can't you say that's the bulk of which it forms a part?
because the bulk changes, it's no longer identified bulk. But if you've got a bulk on a named ship, which is if you look at each of the examples given, if you've got a bulk which is identified, that assumes some stability, some non-changing identity amongst the whole bulk. Once it goes up and out, once it changes constantly, that doesn't necessarily affect the identification of the bulk.
But that's with respect, Mr. McDonald, because I mean, you might be right about the ship example, and we can pick it up from 61 of this judgment, but pretty well all the others, quite possible to have a situation where, as you put it, bits of the bulk are removed and replenished. Identified storage tank, oil, cases of wine, ingots of gold, bags of fertilizer.
I understood that the bulk is defined by it's being contained in a defined space or area.
Yeah, true.
So if I have a particular, I only have one silo because I'm a cheap and cheerful warehouse. I've got one silo. I take grain out of the bottom of it when it's needed, and I've put it in at the top to fill it up again. Is that that's a defined bulk, is it?
So I think the point you've made is a fair one, if I may say. So what I would say is, if you define a space, such as the whole facility, that contains a variety of different commodities.
2 points. You segued very smoothly, if I may say, from talking about a defined space to talking about things that change. Again, I'm just trying to eliminate the second possibility. The fact that things change doesn't mean they're not in a defined space.
I can see that point. So if, for example, you have a refinery tank on shore, which contains 50,000 tons of crude oil, and oil's coming in and out, and you've been promised 10,000 tons from that tank, that's named tank, then I can see that even though the stock is replenished, I can see that may fulfill the requirements of Section 20A.
I mean, the better point here, surely, is that so far as one can tell, these warehouses had at least corn and wheat, and some of them had barley as well.
And sorghum and
sunflower seeds, and that no doubt they weren't all mixed together in silos, but what they haven't done is to identify the silo in which the corn is, for example.
Correct. So
if the warehouse receipt had identified that, even if it was simply to say that the corn was in those silos in the warehouse which are reserved for corn, that would be sufficient, I suspect.
yes. So if you imagine you had 3 silos at the Zaplaski warehouse facility, one corn, one wheat, one barley.
Yeah.
And you said it's in the wheat silo, that may well be sufficient.
Yeah.
But when you've got a defined area, which is made up of different goods, which are not capable of being intermixed, because that's the requirement, then you haven't got a bulk for this purpose. But I quite accept my Lord's point about if you've got a single tank of one commodity which is replenished or removed, that could form part of the bulk. But I would go further and say that so having dealt with identification for the purpose of title, I would say that this provides a stable and certain test for the purpose of identifying goods for identifying an insurable interest. Bearing in mind, an insurable interest normally will relate to specific goods or ascertained goods, but we go further, following Inglis and Stock, to goods which form part of an identified bulk.
Sorry, I'm still struggling with this. I mean, we've put aside the question of goods going recycling, as it were, cycling in and out. Just looking at the definition of bulk, you accept, or you're inclined to accept, that if you have one building in which there are 3 silos, one marked wheat, one marked corn, one marked barley, then so far as barley was concerned, that might constitute
It might.
bulk. Does it matter if you have 2 buildings with 3 silos in each, such that you have a barley in one and a barley in another, and a wheat in one and a wheat in another? I mean, it seems to me, why should it matter? As long as you can say that goods of the same number or quantity are interchangeable with any other goods therein of the same number or quantity, why does it matter? I mean, the point is that the wheat is interchangeable, as it were, within wheat. The barley is interchangeable within barley, and the corn is interchangeable with any other corn in that facility. Why should it matter where the particular silos are located within the facility?
Well, I think it's because when you're talking about a defined space, so one thing the Law Commission was reasonably clear about is that if it's the general stock, then it won't form the bulk. So you can't just say whatever goods which are held by the seller, that won't form the bulk.
I thought that was talking about goods owned by, that's talking about the seller's own stock.
So the goods held here could be part of the facility's goods, but also part of their related companies.
If you've got a silo with 15,000 tonnes in it, and it's a wheat silo, nothing else but wheat, and the warehouse receipt says your 5,000 tonnes is in the wheat silo, what does it matter that the other 10,000 tonnes are part of the general stock? I mean, it doesn't matter, does it?
Indeed owned by some other
Or
person.
indeed
for whom
owned
they
by
are
somebody
also-
else.
So if the question is, if you identify that wheat silo, that's fine. I've got no problem with that. And that's what the decision of the Supreme Court.
Why should it matter then if it's wheat silo 1, which happens to be in building 1, which was the oldest building, or wheat silo 2, which is in newer building 2? You don't care. Why would you care?
Well, you need to know. You need to identify the bulk for this purpose.
Well, bulk is the bulk is the aggregate of silo 1 and silo 2 of wheat.
Well, because what I think is contemplated by the definition in Section 61 is the mass of the same goods in a defined area,
Well,
which are interchangeable with each other.
yes, well, I've just said that. I've got 2 silos, as it happens, of wheat. One is in one building and the other is in my second building.
But you're assuming that assumes you identify the wheat silos. But that's not the case here. All it said is it's held at the warehouse.
Yeah, I'm okay. So I'm sort of going by steps.
Yeah.
So why wouldn't it be good enough if there were, for example, the wheat silos, and there happen to be 2 of them, not just 1?
Well, if it's identified as a named wheat silo, but if, for example, the defined space changes from one moment to the next, the defined space.
Yeah.
So when I gave you the example before of a named oil tank on the shore,
Yeah.
that doesn't change.
No,
But if sorry, my lord.
sorry, but okay, if you might be inclined to accept that if I have 2 wheat silos, it's as good as if I had 1 wheat silo. As long as it only has wheat in it, why does it matter that it has a label
Because it may
saying
change
wheat.
over time. So for example, if you've got 3 silos, which are not dedicated, as my example before, to wheat, barley and...
They'll never be mixed at the same time.
No, but they change. So that it's not, it can't be a defined space. It's changing constantly within.
At any given point of time, it's defined. You could go there and say, my wheat is in one of these.
Yeah, you will know at any time whether you've got wheat in the silo, corn in the silo, or barley in the silo. The fact that, for example, one week somebody may say, look, we've got a big delivery of wheat coming in. Look, we've got a silo which we used to use for barley. Well, just wash it out a bit and then let's have some
Well, I have to say...
wheat in it. I mean, at that time, then it becomes a wheat silo.
But so if I could put the example, just imagine it was this seller has a big facility with a number of different warehouses, which represents his stock, and he's agreed to sell you wheat, and but in the other part of the warehouse he's got wheat, he's got barley, and he's got corn. Now that's just the seller's stock. Now you could say, so long as he's held within, that would be enough for these purposes. But we say no. Because what the definition is contemplating is sufficiently, you can define the area as, in one sense, you go to the entire planet Earth and that won't achieve your end. Or you could do it as small as you like. So there has to be some recognizable limit. And if you look at the examples given by the Law Commission in tab 13, tab 22, sorry, page 529. You've got wheat, so you're referring to named ships, identified silos, identified tanks, identified cellars, identified vaults, identified storehouse. You're not looking at a complex facility, which one week contained one commodity and the next week in one silo, and the same silo can contain another commodity in the following week.
Well, what about a cellar? You've got some Bordeaux in it's all Bordeaux one week, it's all grown, but it's 6 months later.
But these, you can see that what we're not looking at when each of these examples are not looking at an entire facility made up in a large number of buildings. They're looking at individual stores, which can be identified or named.
But it goes back to my Lord's point about if any given moment in time, in that example, the wine that's in the cellar is Bordeaux, and therefore property passes under Section 20A in respect of the 15 cases of Chateau Margaux, or whatever it is. The fact that next week it's got red burgundy in it, it's neither here nor there because property's already passed.
But I would say that the goods within the defined area have to be interchangeable. So if you've got...
In that example, they are. Everything on the day when the property passes, when the conditions of Section 20A are satisfied, all the wine in the bin or whatever it is Chateau Margaux, and it so happens there are
but you then have
25 cases of it, but
you'd have to demonstrate, my lord, that
yours is only 5 cases.
Well, but in this case, if you're looking at particular wheat or corn cargo.
Yeah, okay. Well, let's go back to wheat and corn.
Yeah. But then it becomes a question of identifying. It's not sufficient, I say, to identify the facility as a whole. That's not what's contemplated by the Law Commission's examples, nor by the test. We're talking about a defined area within which goods of the same type are stored with other goods which are interchangeable. And if you've got a large facility carrying...
He's not saying and must remain so forever. Because by definition, this is looking at when does property pass under a contract.
But you can't answer that question on the facts of this case because we don't know whether there were the same goods held in the same silo or how they were distributed through the various bins. And that's evidence is entirely absent.
Right.
But I would say what you don't see in the examples given by the Law Commission is the equivalent of an entire facility which has numerous buildings and warehouses, numerous silos, numerous bins. I mean, we've seen the numbers. They go up to...
Would London City Bond not count as identified seller?
Sorry, the London City...
I mean, London City Bond is a very large, as many of the standard bond storages for wines. Would that not be a sufficiently identified seller if you said 10 cases of Chateau Margaux stored at London City Bond?
I can't answer that question because I'm not knowledgeable, but
Assume that these big bonded warehouses are multiple buildings on a site.
then I think if it's carrying different goods which are not interchangeable with each other, you'd have to identify.
The statute was actually passed, at least in part, to deal with the London wine case.
But you'd have to identify I don't think having. I can't visualize the London Bond Centre, how big or small it is.
Even if you had a single cellar, it's going to have different wines in it. So it's not going to satisfy, if you choose that as your area, the definition of bulk for the purposes of Section 20A. Because it's...
Well, if you look at the example of the Law Commission, cases of wine, all of the same kind. All of the same kind.
But it doesn't mean, that doesn't mean
the cellar
all
only
the wine
it
in the cellar
contains...
has to be of the same kind.
Obviously
It's that the bulk is of the cases of wine of all
No,
the
because
same kind.
if you, my lord, Section 61 not only refers to a defined space of area, it also says any goods in the bulk are interchangeable with any other goods therein.
Yeah.
Any other goods, not just. So it doesn't mean.
Surely that no, wait a minute. That doesn't mean any other goods in the same space.
Why not? Well, so
It says of the same number of quantity. What it means is they're fungible in effect.
Well, you take the example of a named ship. Take the example of a ship that's got
5 holes.
wheat in 3 holes and corn in 2 holes.
Yeah, but you'll have a bill of lading which identifies all the wheat or corn in hold number 1. And that may be an undivided bulk in hold number 1. And that would be sufficient for these purposes because all the goods in that space are not interchangeable with any other goods in the same space.
Well, it's in the same bulk.
So they are interchangeable with any, but they're not interchangeable with any other goods in any other hold. So what you're really looking for is you have to have this, if I could put it, this purity of identification of goods in the sense that they've got to be interchangeable with any other goods in the same space.
So you're saying that no one space can contain more than one bulk.
No one space can contain more than one bulk of the identified goods, yes.
So in my simplistic wine cellar,
Which
I have
okay.
let's assume for present purposes it's much less grand than
I can
the
see
commercial
that.
court wine cellars at the other end. Let's assume that I only go for one red and one white because I'm a simple bloke.
Yeah.
And I walk down to my wine cellar and the reds, it's all the same on one side and the white is all on the other side because I just like to be able to.
So it's
tell
divided
which is
into
which.
2, yes.
So you just walk down the middle as red on one side and white on the other.
Well, if I buy
I only buy
10 cases of red wine.
I only buy one red and one white. I've got one wine cellar. I've got cases of red down one side and cases of white down the other. They're all the same white, they're all the same red. It's one cellar.
It's one defined space, but you can't say all the goods,
So
any one good is interchangeable with any other goods in the same space.
all my reds are interchangeable with all the other reds and all the whites are interchangeable with all the other whites. Well, why wouldn't that constitute 2 bulks, one white
Well, there may
and
be,
one
but
red?
you have to identify the area. You have to
It's my wine cellar.
Well, if it's an identified area, so what you need is a defined space or area. So if you define the space as the left-hand side of your vault, which only contains red wine, that's fine. If you define the area as your vault, which contains a number of different wines, that is not fine. Because you can't, my lord, you can't get away from the words. It's got to be interchangeable with any other goods in the same defined space.
No, it isn't. It's in the same, that's the point I've just made to you. Just before that, it doesn't say in the defined space, it says such that any goods in the bulk are interchangeable with any other goods therein.
Doesn't
i.e.
say in the defined
bulk.
space.
That's exactly the point I'm putting to you.
And if you look at the examples, that in the
So
commercial
that's exactly
sense,
the point I'm putting to you. It's interchangeable in the same
Yeah,
bulk.
but the bulk is defined as a mass or collection of goods of the same kind in the defined space.
Yes, but it doesn't say that you can only have one bulk in one space.
I think it is, my lord, if I may say so, because the definition of bulk includes the defined space or area. You can't divorce it from that. You can't ignore it. It's defined by reference to it. So what it means is any goods in that space, define space.
So, okay, so you're saying it's okay if I define the space or the area as the right-hand side,
Correct.
not the left-hand, I
That
suppose
would
the
be fine.
left-hand
If you
side.
define the space as the entire vault, any goods in the bulk, which includes the defined space, are not interchangeable with any other goods in that space.
I think the examples we've been giving about people's cellars, which the Law Commission obviously thought what were something that you could have, came with the definitions.
Well, it does say-
that can't be what they intended it to mean.
Well, you say that, my lord, but that's, if you look at the example they give is wine of the same kind.
But,
It
it's,
says that.
but you can look at any number of these examples which the law commissions give. And in commercial terms, the entity which has the warehouse or the vault or the storehouse or whatever it is going to be storing a large number of different types of goods, different types of fertilizer, for example, different types of wine, different types of different grades of gold or whatever it is. And they can't possibly have intended that this would only cover a warehouse or a storehouse where only one type of fertilizer was being stored.
My lord, I think what I would say is, I think that the normal, if you like, mischief at which this legislation was aimed is when you really had goods loaded on a ship or stored in an oil storage facility, which were mixed with other goods, and you bought part of it, and you knew exactly what that tank was or what that ship's hold was.
Yeah.
That's what it's getting at. What it can't be getting at, I submit, is where you have an entire complex carrying with a large number of silos or warehouses, and that in turn divided into numerous bins, just saying all the wheat contained in that entire facility. I mean, in the same way, I could say all the wheat contained in any of our 10 facilities. That couldn't possibly be sufficient. There has to be a limit. And I suggest the limit is to be found in a definition of bulk, because that's the mischief which is getting at. Otherwise, it's really extending the legislation beyond, I think, its intended scope. But I'm just, again...
Anyway, this whole discussion came out of your fundamental submission, which is that the test under Section 20A and Section 61 of the Sale of Goods Act should equally apply to whether or not there's an insurable interest.
Yeah, I am responding to my response.
I understand,
Yeah.
but I mean, that's the context.
Yeah. So I say that this provides a stable definition in the sense that the divisional court equated right to possession with title by reference to the same definition.
Mm.
And it would be very strange if other types of insurable interests would be applied by reference to identification would be determined in a different way. And that would be, I think, a detriment in the law rather than a benefit. If you want certainty, you want to know exactly what can and can't be insured. And my lord, the last point, I'm sorry, I'm taking far too much time. But-
We're probing a lot of questions.
No, and I welcome it, my lord. But the third ground, which I can deal with more briefly, is the immediate right to possession. Unfortunately, it raises a number of issues which I'll try to deal with as I can. There's a prior point here, which is what's the relevant applicable law? Is it Ukraine law or is it English law? And the position we submit is it must be English law for these reasons. Either the issue of Ukrainian law wasn't pleaded, or if it was, there's a presumption in the absence of evidence that English law will apply. So these are the two rules which I think Lord Leggett laid down in Brownlee. I don't know if I need to take you to those two rules, my lord, but the default rule essentially is if there is no plea of foreign law, then the default position is English law will apply to the question. If there is a plea of foreign law, but there's no evidence as to what that foreign law is, then the presumption is that English law will apply. Now, there are exceptions to that, but that's the general position.
If that is a presumption which is applied flexibly
It is.
according to a test, which I may get this slightly wrong, but is essentially whether it's reasonable in all the circumstances to believe that the foreign law is likely to be, I think that's the expression, is likely to be the same as English law. And that may be something you can think more easily of a common law system and so on and so forth.
Well, but
that's ultimately the test.
Yes, and I think if the expectation is also that there's no reason to suspect that the foreign law would be different from English law, whether it's common law system or a commercial law, whatever it might be, that's another factor one takes into account. And so it doesn't have to be a common law system which this presumption applies to. It can apply.
Is likely to be materially.
Yes, although I mean, it's true to say a lot of the commercial law in this country is mirrored in the commercial law of European civil law system.
No, I'm not from suggesting it's limited to common law systems.
No.
And if one's simply talking about, our parties are obliged to abide by their contracts, one might take that as read under most systems of law.
Now, as to the issue whether this issue is pleaded, I think it's fair. I could go through the pleadings in detail. I don't want to, but there is one plea which I suspect my learned friend will go to, which is paragraph 7.2 of the reply, which is probably worth looking at, which is at the core bundle, tab 16. The reason we've got to 7.2 is there had been a claim made in relation to the warehouse, the cargoes represented by the warehouse receipts. And in the defence, we took issue as to the validity of the warehouse receipts as a matter of Ukrainian law. And that was the subject of expert evidence as stipulated by the judge hearing the case management conference. And there was evidence on that heard.
And to what issue did that go?
To the formal validity of the warehouse receipts.
Yes, but to what was that relevant? If they were not valid under Ukrainian law, then what?
Not sufficient evidence of what they contain, because what they're supposed to do is comply with local law. But we're not pursuing that on appeal now.
I'm trying to understand what there was squarely an issue and Ukrainian law on whether the warehouse receipts were valid.
Correct.
What I'm just seeking a bit of assistance on.
Why?
Why did that matter for the arguments in the case?
Yes, it was relevant to the arguments in the case.
How? That's what I'm
because
asking.
as to the weight to be given to them as evidence of the facts they contained. So, for example, where they're issued not in accordance with local requirements, where all the other warehouse receipts we saw were, these weren't. And there was a question as whether they were invalid or valid. And we said it went to the weight to be given to the facts.
It went to the evidential weight you could attach to them.
Correct.
As to the existence of goods.
Yes, amongst others.
Whether they were valid as a matter of Ukrainian law.
Yes. But my lord,
Strikes me as something to which that Ukrainian law issue wouldn't go at all.
can I just say what this is not
I thought
relevant to the
we
appeal.
went to the
No,
issue
I-
of whether immediate possession.
Quite.
Didn't it go to that issue?
So,
Because what was said by Mr. Kershit's clients was
Yeah.
that these warehouse receipts give us an immediate right to possession.
They
And
do.
you said, oh, well, that's all very interesting, but as a matter of Ukrainian law, they're not valid because they haven't got 15 stamps on them. And the judge found that was not correct.
correct.
That's the point, isn't it?
Yes, I see that. That's true as well.
You're getting,
So Ukrainian
like
law
they
was.
say, you're getting confused. Don't mind me saying.
So I actually don't think that's right, my lord, because what the question being asked by it's a long time ago, and it's not relevant to this appeal. But the reason, and I, if possible, I'd like to avoid arguing points which are not relevant to the appeal, but I'm happy to do so if necessary. But the reason I don't think that's the case, and I could be misremembering, is because the judge hearing the case management conference didn't order the determination of the issue as to whether or not there was a right to possession under Ukrainian law.
Well, that may be because that was the only thing to which the validity of the warehouse receipts could sensibly have gone. And you say you don't want to argue something that's irrelevant, but as I understand it, the point you're on at the moment is that the default rule of English law applies because Ukrainian law wasn't raised as applicable to what we're concerned with on ground 3, namely, was there an immediate right to possession?
Correct.
And what I'm putting to you is, I don't at the moment see what else in the case it could have been relevant to.
Well, that would, well,
I mean, your answer to me was it was the evidential weight
well, that
to
was
be
my-
attached
that's my
to the warehouse
recollection, my lord.
receipts. But I
that
have
was
to
my
say, speaking for myself, I don't really see how the legal validity could really play any part in the evidential weight as an element of were the goods there or not.
Well, let me remind myself overnight, and I'll probably, if I can give you an answer in the morning, because I just don't remember.
Yes.
But just, and I see the time, but the point I wanted to make is this, that our expert, Gay, did give evidence in his report that the warehouse receipts granted a right to possession to the goods as a matter of Ukrainian law. And that was uncontested by Quadra's expert. So this is the way the evidence emerged. But what there was no evidence about is to what happens when you have competing warehouse receipts.
Sorry, what?
When you have, there's no evidence as to Ukrainian law where there were competing warehouse receipts. It was looking at a single warehouse receipt. And so that was the issue. So the question is whether this issue was pleaded or not. And at paragraph 7.2, at page 247, you'll see that Quadra plead by reason of the relevant Ukrainian law and for the reasons found by the Odessa Commercial Court, the warehouse receipts confirm a contractual relationship between the claimant and Zaplasky, Bilgorod and Ismail warehouses, pursuant to which the warehouses agreed to store cargoes owned by the claimant, which cargoes the warehouses were obliged to deliver up to the claimant. Now, what we say is there was no issue, and this was a response to our argument that the warehouse receipts were invalid because of their lack of formal validity. And so the question arises whether or not the issue of the Ukrainian law dealing with competing warehouse receipts was or was not pleaded. Now, the answer is, we say it wasn't, but if it was, you fall into the presumption. So it's either not pleaded, in which case it's a default rule, and if it was, then you have the presumption. Now, what was conceded during the closing submissions at trial was English law was the applicable law for this question. And I can take you to the transcript if it helps. So we say one way or another, you end up with English law. But the reason this point's important, it really goes back to the issue raised by the divisional court. And it's equivalent to the nemo dat rule. And that is, if you've got 6 warehouse receipts being issued for the same goods, and the first one grants a right to possession, the latter to those goods, to one party, the latter warehouse receipts can't do the same thing. In the same way, is if the first, the goods are sold to one party, any purported sale of the goods to subsequent parties will be ineffective. Now, my lords, I just have I'm not going to say much more about that. I have a little bit of homework to do.
Well, have a think about it overnight, because we really do have to rise.
I know.
I'm slightly troubled by all of this, by what was said by Lord Justice Males in relation to the refusal of permission, and specifically what he said in paragraph 11 of his judgment. Because it did seem to me that this was a point that had been shut up by what Lord Justice Males said.
Well,
As has, in fact, the argument that, because he says in terms that the issue whether there was a right to possession under Ukrainian law as a result of the warehouse receipts was put in issue on the pleadings.
he does say that, my lord. He also says, knowing that this was an issue in relation to, because he was dealing with a point where he did not give permission to appeal for. So this is a related point, but he does say at the very end of his judgment, paragraph 20, I think, that this is not intended restrict the scope of
To
permission.
limit the scope of the permission
Which
that
has
had
been
been
granted.
Right.
So all that was, I would take that as an indication of Lord Justice Mayall's opinion on that issue, but it's not binding
Right.
for the purpose.
Just before we break, tomorrow I welcome some assistance on what's actually in his order. Paragraph 2, where it says it's not open to them, that's your clients, to contend there were in fact parties with such competing interests when they didn't seek to prove this at the trial.
Yeah.
But I'll leave that to you to come back to tomorrow, because we have to write that.
So I'm very sorry I've taken so long.
You haven't finished today, and I'm not criticising. Do either of you think it's necessary for us to sit at 10 o'clock tomorrow, assuming that we were able to?
Well, it depends on my learned friend. If it's necessary, I'd prefer to, but if it's not, it's up to me.
Well, I think we probably should in that case. We'll sit at 10 tomorrow.
Okay.
All right. To receive that.
Thank you very much.
All right.